Namaskar. Welcome to my channel Journey of Constitution of India. We are watching part 4 of Article 16 Equality to Opportunity in State Employment series. In part 3 of video, I have discussed in detail about the Indira Sawhney judgment, which is popularly known as Mandal Commission Case. After the pronouncement of this judgment, the government came into action and Justice Ram Nandan Committee was appointed, and that submitted its report in 93 only. It was accepted also by the government, and immediately the National Commission for Backward Classes were constituted. But this commission got the constitutional status by amendment, 102nd amendment of the Constitution, Constitutional Amendment 2018, and the commission is functioning. After 1993, there were several judicial pronouncements came, and which created barrier for the government to against providing reservation to backward classes or scheduled castes and scheduled tribe. So various amendments were introduced in Article 16, and these all amendments were challenged in 2006 in M.Nagaraj judgment, and wherein amendment 77th amendment, 81st amendment, 82nd amendment and 85th amendment were challenged, whereas 77th, 81st and 85th were amendment in Article 16, and 82nd amendment was by inserting a proviso in Article 335. It was a constitution bench presided by Chief Justice Y.K. Sabharwal, and the case was M.Nagaraj versus Union of India. However, I have dealt with all these amendments which were challenged in the same Nagaraj judgment in my part 2 series, part 2 of Article 16 series, but I'll give some brief description about it so that better understanding can be created. While 77th Amendment, Clause 4A was inserted in 1995 in Article 16 for continuing with reservation in promotion of scheduled caste and scheduled tribe. Whereas by 81st Amendment, another clause 4B was inserted in Article 16 for making carry forward of unfilled seats as distinct class to overcome the ceiling of 50% created by Indira Sawhney judgment. And so the government created a novel concept of making these unfilled seats as in unfilled posts as a distinct class. By the 82nd Amendment, a proviso was inserted in Article 335 for providing relaxation in marks or evaluation for promotion of scheduled caste and scheduled tribe to overcome the barrier or hurdle created by Article 335 as a efficiency in administration. The Supreme Court in S. Vinod Kumar versus Union of India in 1996 ruled that relaxation of qualifying marks and standards of evaluation for reservation in promotion were not permissible. So this 82nd amendment was made, and so that this efficiency barrier can be overcome. In 85th amendment, the word consequential seniority was added in Article 16 4A, so that it can provide the seniority to the scheduled caste and scheduled tribe after the promotion. And why this 85th amendment was inserted? Because there were Supreme Court judgments. One was Union of India versus Virpal Singh Chauhan, and the other was Ajit Singh Januja versus State of Punjab, where it is specifically said that this promotion seniority, carrying of the seniority promotion after the promotion in reserved category was not permissible. In Nagaraj case, the main challenge was on the ground of violation of basic structure. So first we should understand what the basic structure is and how it has evolved in the Indian jurisprudence, constitutional jurisprudence. Let me tell you one thing, interesting fact, that the doctrine of basic structure has essentially emanated from the German constitution. Because in German constitution, Article 79, Clause 3 of the Basic Law of Federal Republic of Germany, which was adopted in 1949, especially bars explicit amendment to the provision of the federal structure. It bars the provisions, amendment to the provisions of federal structure, whereas it also bars the amendment of the basic principles, which is enshrined there in Article 1 to 20, related with the human rights as well as democratic and social setup. And so this concept has emanated from there, and that was adopted in 1949 when our constitution was also under frame. But in Indian context, particularly in the Indian jurisprudence, this concept was first theorized by Justice Mudulkar while he was writing a dissent judgment in Sajjan Singh versus State of Rajasthan case, and where he doubted whether the ambit of Article 368 can be enlarged to the extent that it can alter the basic structure of the constitution, or it can rewrite the constitution. So first we have to understand what is the basic structure, because the theory is there. But what is exactly the basic structure? So I find this Nagaraj judgment is a great piece of work to understand the concept and evolution of basic structure doctrine in Indian context. Let me share a beautiful explanation given by Justice Kaparia when he was authoring this judgment of Nagaraj. He said the basic structures are something beyond words of particular provision. So it is a systematic principles underlying or connecting the various provisions of the Constitution. These principles give coherence to the Constitution to make it an organic whole. So basically what comes out? That there is these principles are part of constitutional law, even if they are not expressly stated in the form of rules. Even if it is not defined, if it is not put in a particular article or particular provision. So as, for example, the principle of reasonableness is not written anywhere, but it connects Article 14, 19, 21. Some of these principles, the underlying principles, are so important and fundamental that they qualify as essential features or part of the basic structure of the Constitution. We can say that these principles are not open or not amenable to the amendment, because on amendment of it, the basic concept and basic underlying principles will be altered and the Constitution will be a different Constitution, which was not envisaged by the founding father of our Constitution. Because this Constitution is a living document, it has a distinct personality, distinct characters it has been put into it. And so, while dealing with this judgment in M.Nagaraj, the Supreme Court relied heavily on the judgment of S.R. Bommai. Because where in that case, it was found by the court that, and the court's conclusion based on the fact that if a series of violation of a series of evidence which provides that the basic principle of secularism has been violated by the state, then that empowers the center to take action against the state. Here, the secularism is a basic principle. It is not defined anywhere in the Constitution. There is no specific provision, but there are several provisions, several articles which interconnect and is interconnected by the concept of and by the principle of secularism. Like other important point, principles of federalism, principle of reasonableness, socialism, these all are basic features of the constitutions. They are systematic and structural principles. They connect the Constitution. They are part of the constitutional law, even if they are not expressly stated in the form of rules. Now, basic principle vis-a-vis amendment. So, to qualify the essential feature of the Constitution, first the principle has to be a part of the constitutional law, and second, it has to be a binding effect on the legislature. Then the next stage comes, whether it is so fundamental that it can prevail over the amending power of the parliament. So this is the standard of judicial review of constitutional amendment in the context of basic structure. The theory of basic structure is based on the principles that a change of a thing does not involve a destruction of the thing. If any amendment destructs the basic qualities of the Constitution, then it is prohibited. Therefore, the validity of impugned amendments of the Constitution to be judged on the theory of basic structure. Now, what is the concept of equality and vis-a-vis the amendments which are impugned here? Because the issues in the amendments were consequent seniority, carry forward of vacancies as a distinct class, or relaxation in the evaluation or standard of for the promotion of the scheduled caste and scheduled tribe. So these were to be tested before the doctrine of equality, because equality of opportunity is provided in Article 16, and it has two phases. This equality of opportunity has two phases. First, a non-discrimination principle. But second, which is also equally important, and it is a facet of the equality of principle, is the affirmative action by the state. Because state has an obligation to provide a level playing field for all classes, and particularly making some provisions in favor of the oppressed class so that they can come to a level playing field. So affirmative action in the above sense seeks to move beyond the concept of non-discrimination towards equalizing result. And these two concepts constitute the equality of opportunity. So whatever the amendments were made by the state as an affirmative action to create a level playing field for the oppressed classes. So this considering affirmative action as a facet of non-discrimination, insertion of concept of consequential seniority code or reservation promotion of ST/SC or unfulfilled vacancy as a distinct class would not violate the basic structure of the equality code of the Constitution, which are enshrined in Article 14, 15 and 16. So the Supreme Court in Nagaraj case upheld the constitutional validity of 77th, 81st, 82nd and 85th Amendment. It further concluded that government has to demonstrate the backwardness of scheduled caste, scheduled tribe beneficiary every time reservations were provided for promotion. Secondly, it also mandated that government has to provide with the quantifiable data that there is an inadequate representation in the particular category of job where the reservations are provided. The third important point was that creamy layer of OBC do not have the right to be a beneficiary of the reservation policy. However, the court held that no such exclusion of creamy layer will be applicable for scheduled caste and scheduled tribe. So this scheduled caste and scheduled tribe discussion or this dispute was settled. Their backwardness criteria was settled by the 117th constitutional amendment, and that clarified that all scheduled caste and scheduled tribe are deemed to be backward. So not to be proved or not to be the data to be collected to bring them in from outside the creamy layer on like this thing. This judgment was again this judgment was again considered in Karnal Singh judgment in 2018, and that we will be dealing in the next video. Thank you very much for watching this video and being with me in the journey of Constitution of India. Thank you very much. Please subscribe my channel so that the video can reach to you immediately after at the time of its uploading. Thank you very much. Namaskar.